Welcome back. It's Philip Bickle at Legal Tyranny. It's July 16th, 2021, and we're going to wrap up the argument and conclusion section of my traffic infraction appeal reply brief. Let's get started. Alright, this notice of infraction that the appellee relies upon to indicate that I was given notice of alleged prosecution of the poorly conveyed codes was completed knowingly by Officer Davies with false information. He admits under oath that he didn't know for a fact if I was the registered owner. The prosecution has never provided any evidence supporting that I was the registered owner of the Ford F-150. I provided evidence that I was not the registered owner at trial with the certified California DMV registered owner search results. See Exhibit J. That was a printout from the DMV. And if you're in California, it's like a blue form. Everything's printed in blue. Let's see. Only automobiles with original registration are issued number plates and are required to display them. See HRS Statute 249-2, 249-7, 249-9. The Hawaii Supreme Court has weighed in on this, to wit. Jim's argument that did not have state-issued license plates, so it would have been impossible for him to improperly display plates that he never possessed, is clearly flawed. Number plates are all issued to all originally registered cars. See HRS 249-7A. Okay. And Jim does not assert that his truck was unregistered or stolen. There's your two defenses. They're telling you what your two defenses are to this charge right here, being if I was actually charged. Okay? They never properly charged me on any of this stuff. But if they did charge me and say that, hey, he violated this statute right here, 249-7. No, I didn't. My truck was not registered. I asserted that. I asserted it right off the bat. And I asserted that it wasn't even required to be registered. Okay? So that's not really an issue there. Like, these guys don't make an issue of that, but they're not going to, because they don't want people to realize that there is a class, a huge class of automobiles that aren't required to be registered. Now there's others that, you know, if something happened, which is, I don't know, it could be likely in this day and age, they, you know, the IQ of cops has dropped. They've intentionally been hiring more knuckle draggers that just follow orders. Not all you guys are like that. I know that. Okay. All right. Everybody's unique, but if we look statistically on the whole, there's just been an IQ drop. Massive. And it is what it is. But, you know, these guys aren't the sharpest, and they certainly aren't sitting around reading law, reading the codes that they typically enforce. Hey, do I know this well enough, and am I doing this right? No, they're not going to read that. They're just going to do what the prosecutors tell them or what they're trained in academy for, I don't know, 4 to 6 months. So, I alleged that it was unregistered. That right there is enough to get this, at least this one, dismissed. But the one where I was alleged to not have registration in the car that the judge dropped at the lower level, I didn't need to appeal that particular one because the judge dropped it. And the reason why he dropped it was because it was unregistered. If you're unregistered, you're not issued registration. You cannot have registration if you're unregistered. They're just diametrically opposed positions. It's true or false. That's it. No in between. Now, somebody could also allege that they had their automobile stolen. Now, I haven't looked closer at this case. I'd like to look at it. It's possible I doubt the guy was per. He might have been. If he was per or pro se, he may have made similar arguments or very close to the same arguments as me. It's hard to say. Some of these people don't go deep enough. Well, most. I don't think anybody's gone deep enough for my liking, other than maybe other lawyers like Lawyer Dude. Like, they really get into the nitty gritty. Alan Iverson does a pretty good job on a lot of his stuff, and there's a few others, but most people don't go deep enough. They don't sit and read the codes to know, what they should be arguing. In this case, this guy, he may have registered at one point in time and then let it expire, but if he had registered and then not, sent them back stuff so that it would be voided, he wouldn't be able to make this argument here that it was unregistered. If he, within the same time frame that it was registered, decided to go out without a plate, then yes, he would have been in violation of this code, because it was registered. He did not do anything to rescind that registration and get their acknowledgement on it. And in my case, I did the easiest thing possible, which is I just let it expire in California. That was it. The guy that I got the truck from, he was the last person to have it registered. I just let it expire, and at that point it went into that category right there of unregistered as opposed to registered. And, if you're in a situation where your plate was stolen, you would be able to make this argument here. Okay, so the alleged violation of 249-7 listed on the citation cannot stand, given that it only refers to registered owners. The officer involved made a false report, and the entire citation should be thrown out. Officer Davies was given evidence that indicated that I was not the registered owner of the Ford F-150 by myself and by doing searches through Hilo dispatch. Yet he still marked down in two separate instances that I was the registered owner. That was for the traffic arrest citation, and then separately for the traffic infraction citation, which this appeal is dealing with. And in this, where I was asking about the traffic crime arrest, it's because this was during trial, and they were dealing with both of those separate citations in the same trial. Just for clarification. Okay, the two citations that he issued to me were false reports, and he knew this because he knew he did not have proof of registration. Filing false reports is a violation of HRS 710-1015. False reporting to law enforcement authorities. A person commits the offense of false reporting to law enforcement authorities if the person intentionally makes a report, that's a citation, or causes the transmission of a report, that's a citation, to law enforcement authorities relating to a crime or other incident within their concern when the person knows that the information contained in the report is false. Boom, right there. He's done. He committed 2 misdemeanors. False reporting to law enforcement is a misdemeanor. That's 2 misdemeanors. And we're not even getting on the perjury issue here, where we caught him falsifying and changing his testimony. Okay, but this one, like perjury, the way the statutes are set up on perjury, pretty much in every state probably, they allow the judge to determine if perjury was committed, rather than a jury. Now, why would they do that? They're doing it because the judge can act to protect their agents. The judge can step in and say, this person did or didn't do this thing at this point in time, and they knew what they were doing, and at this later point in time, they did this thing that completely contradicts it, and they also knew what they were doing. And it all had the intended purpose to change the way things were going at trial. That's perjury. Now, that should be in the hands of the public. Like, the determination of perjury should not be in the hands of the judges, because they just pretend as if the cops are not committing perjury unless the courtroom's full of media. So in my case, I nailed him. Like, just nailed him. Completely nailed him on it. And, this alone is terrible. Two misdemeanors. Two of them. And that was all within the first week of me encountering him over this citation business. All within 7 days, he committed 2 misdemeanors there. And then the perjury occurred over time with the appearances and testimony that he gave. And, they didn't realize if he didn't do anything wrong, I could have never gotten him on perjury, or, to admit that he filed these things unlawfully. If he did everything correct, if he followed the law, I couldn't get him on that. There's no way, like, it's not like I tricked him into doing something. He didn't follow the law. And the easiest thing that he could have done was follow the law, and first and foremost, not file false reports. But, he stopped me, and I guess they wanted to get me on something. You have to be a registered owner for them to nail you on just the initial reason he stopped me. I'm going to have to put up the audio record. I have the audio. I don't have the video anymore. But the one hard drive is damaged there. But I have the audio of him coming up to the car, because I think I had 3 different recorders going at the time. He only noted the one that was up in the window. But I think I had that, and then I had a separate Olympus recorder, and then my phone. So I had like 3 recordings of it. I have him very clearly stating as he came up, hello, I stopped you because you don't have a plate on your car. That's what he said. He didn't say anything about the other 3 infractions he hit me with later, and that the prosecution kept reiterating were his reasons for stopping me. They changed his reason for stopping me. So, and they got him to testify to that too. How good is that going to look if I took the time to figure out how to enter the audio evidence into the record? That was more of a pain in the butt, which is why I didn't enter that particular part. But, I got him on enough stuff. In this case, the judge just let him right off the hook. It was like, he said this, and then he said a different thing. I think I have a short clip of the video up, and if I don't, I'll have to find that and put it up, because it's just disgusting, how belligerent the judge is with his bias. Okay, his behavior of filling out the officer's statement of facts after he already issued copies to me gave him time to think of how he was going to fill out the facts based around the alleged violations that he had selected and used to justify his unlawful warrantless arrest. Each of the false indications that I was the registered owner is a separate instance of filing a false report. So 2 of them. And he made a unlawful warrantless arrest. That's the core of the issue here. That it was an unlawful warrantless arrest. But, the fact that we got him acknowledging that he filed false reports and didn't know certain facts, that's the most important aspect of this reply brief. Okay, conclusion. Reversal is required based on judicial bias and prejudice, due process violations, and violations of my protective rights under the law, as described in the opening and reply briefs. Defendant appellant respectfully requests that this court, 1, order that the April 12, 2019 judgments in favor of the state, entered by Judge Harry Freitas of the District Court of the Third Circuit, be reversed. Okay. And our certificate of service. This is practically a copy of the very first page. Most of you will notice we have the header info here. But you have to have this, again, this is a Hawaii electronic filing system. And I would do everything snail mail until you've studied this stuff long enough to make that decision if filing electronically is beneficial to you. But that's it. And these are the 3 arguments for my reply brief here. And if you found this informative and useful, please give the video a thumbs up. If you're not subscribed, consider subscribing. And if you are subscribed, please consider hitting the notifications bell so that you get a heads up when I make my video postings. And as always, any of you that can copy and paste specific videos that you believe other people would benefit from, it helps me out with getting the info out there, and other people will benefit. So until next time.